It's Tuesday morning, so it's time for you to get some free legal advice from David Whiting, Melbourne City lawyer, who has never been asked a question he couldn't come up with an intelligent answer to. Is that right?
That's different from the right answer, isn't it, Raph?
Not necessarily.
Okay.
They're
right.
not mutually exclusive.
No, they're not.
You're always able to come up with
They're not the same set.
No.
No.
But you're always able to come up with
something, and the answer's like, well, if I don't have an answer for it, I'll give it to you next week.
Now, my close friend, the Immigration Minister, Peter Dutton, did not deliver to me a quote that got him a lot of coverage yesterday, but did speak to his other close friend, who's also in my drinking circle, Alan Jones.
Yes.
And he accused lawyers who were trying to keep, there's about 400 people who've come here for medical treatment and do not wish to return to Nauru and PNG. He accused lawyers helping those people of being un-Australian.
Yes, I saw that,
was
and I just thought, absolute wow. And if you went on and read the article, you find that his problem is that the law doesn't support his view. And he would have difficulty getting changes to the law that he'd like through the Parliament. That creates an impediment. So instead of having a problem with the structure in which we operate, he in fact decides that he'll attack the people who are using the structure within we operate.
Can I Can I channel Peter Dutton? If you use a legal process to get around a policy that's been settled on by the two major parties, does that make you un-Australian?
No, not at all. You have a legal framework. The answer would be otherwise. Let's make decisions on the fly, and let's retrospectively change everything that we do. You set the rules. You wrote the rules. If you didn't write them properly, that's not my fault. If you didn't write them to achieve the outcome that you wanted, that's not my fault. Once you find that there's a mistake in what's happening, then you go and you change the law.
And I guess it's whether or not you believe that due process and the legal system are, and the ability for that to frustrate a government from enacting what it's been voted in to do. Do you believe that is a feature of the system, or do you believe that is a bug in the system, a wrinkle of the system? And it's a feature, isn't it?
Well, it's a feature. I mean, we have three arms of government. We've got the legislature, the executive, and the judiciary. And they are parts of checks and balances on each other. Each is supposed to make some attempt to deal with the excesses, one and the other. And if you simply turn around and say, I mean, I actually got a letter from a council the other day that says, if you do X, Y, and Z, you'll be guilty of an offence. And I thought, well, that's not quite the way I understand it. If I do X, Y, and Z, you may choose to charge me with an offence, but presumably the magistrate's court that you might take me to is redundant as part of the process. That's the Peter Dutton model.
I'll get onto some calls in a moment. However, you briefly mentioned a statistic to me about the clogging up. Well,
there was an article in the Australian in the last couple of days that talked about the amount of the workloads for family court judges. And last week we talked very briefly about a review of the Family Law Act and how it's working. What we've got at the moment is we have judges in the Sydney and Parramatta registries of the family court, and that's the only registries I've been able to get statistics for. The judges are handling each between 300 and 600 cases. Now,
that's insane.
Oh, yeah, absolutely.
Hundreds of cases per judge.
Yes, right. So it's this juggling exercise, and how often do you come before the court? What kind of disagreements are you going to have? How do you get a court time so that the judge actually understands all of the factual issues? I mean, I had coffee the other day with a recently appointed magistrate, and that magistrate was saying that in a magistrate's court, there's about 4 to 5 minutes allowed for lots and lots of matters in the magistrate's court. So there's just simply not enough time. It's a process. You know, if you've got 300 cases for the day and you're going to be sitting for 5 hours, so you might sit, say, from 10 till 1, and then you might sit from 2:15 to 4:15. So 6 hours. 300 cases, I've got to do 50 an hour. I'm sorry.
It's nuts, isn't it?
Yeah, absolutely. Anyway, that's the system, And there's another suggestion out of New South Wales that we ought to increase the retiring ages for judges. Judges now reach a point of what's called statutory senility, and beyond which they're not entitled to sit on a regular basis.
It's called statutory senility.
It is. The age of senility. Right? And so that was put to me by a family court judge many years ago. And the proposal is that you now you make the retiring age 75. So,
do you agree?
I actually think you burn out. The burden on judges, I think, is an extraordinary workload. And when you get once you've reached the retiring age, you're able to say to the registries or to the court system, I'd like to work less days, and they then move you to a daily rate, and you simply do daily work.
They don't retire them on the Supreme Court in the US.
No, well, yes, but you see, we used to have.
Workload.
No, it's more that there's no retirement age built into the Constitution. And so they could change the Constitution to include a retiring age for Supreme Court judges, but it wouldn't affect the ones who are there.
No.
Yes.
Lawyers, judges, retirement and statutory senility. It's 11 minutes past 10. Let's go to Trevor, who's in Doncaster. Go for it, Trevor.
Hello, David.
Trevor.
I'm interested in the legal liability of a tenant or an occupier of a property when a bill arrives from the electricity provider addressed to the occupant.
Most electricity bills have names on them.
The reason how this arises is I'm a landlord and I have people move out of a property and they ring up their electricity provider and get a reading.
Yes.
Now, in the old days, the SEC used to disconnect the power.
Yes.
The companies don't do that anymore. They just read the meter. So the power is still connected after the tenant moves out. Now, sometimes their moving out is delayed. They're building a new house or something and the days vary. So when I come in to do the maintenance work on the property and get the power connected in my name,
yes,
I find that I've got a bill arrives in the letterbox. It might be for a few days, it might be for a few weeks, depending on my circumstances, etc., and it's addressed to the occupant.
Trevor, it's not your responsibility. You have no contract with the electricity supplier. So the bill that you've described is not yours. You apply for a connection, you're liable under that connection. Does that help?
That was my understanding. Now, when this first happened a couple of years ago, I assumed that the previous tenant hadn't disconnected the power, so I used it. Now, I ran up a couple of $100 on a bill.
Yes.
And I contacted the company that was sending me this bill, and I ended up in a compromised situation. I forget the details of it, but
in the situation you've described, Trevor, you in fact used the electricity.
That's correct.
I had assumed you were talking about. You were the occupier at the time the power was being used, even though there would be an argument as to whether the electricity company knew you were an occupier, but that's their problem, not yours.
Yes, I understood that and settled the account with them. But in circumstances where you've got pilot's lights going with the gas and you've got electric hot water operating in the ceiling, and you don't even have access to the property yet. So when I ring up and connect, it might be 2 weeks before I get access to the property.
Yes, but it's at that point that you become the occupier, Trevor.
Right.
I mean, that's the point at which you start using the services.
Right.
Now, you would go back to the electricity company and say the tenants who were here before didn't move out until such a date.
Right.
And that's the date I applied for the new connection. All right.
Good luck, Trevor. Rosemary's in Cheltenham. Rosemary, go for it.
Oh, good morning, Raph and David. I have an investment property. It's a ground floor unit. The unit upstairs had a problem with a water leaking into our apartment, and the insurance company, For the Body Corporate, sent around a company that serves as an assessor, they go round and check the plumbing, etc.
Yes.
And they decided that the membrane in the apartment above us needed to be repaired, and the insurer sent us a letter indicating that they weren't prepared to repair the damage to our apartment until such time as the works had been completed upstairs.
Yes.
The owner of the apartment upstairs, I have just found out, had no intention of having the membrane done, has had the whole bathroom renovated, and now the insurance company won't agree to doing the repairs to our bathroom because they say
Does
that
the people
it
in the
could happen again.
Yeah, the answer is, do the people upstairs say they replaced the membrane?
No, they said that their tiler told them it wasn't necessary, but we asked them over and over again to provide a second or a third opinion by a person qualified, such as a plumber.
Yes.
And she didn't do that.
I mean, I can say, Rosemary, I have sympathy for the insurer.
Yes.
Because they need to, otherwise they're going to be coming in every few months and redoing your ceiling.
That's correct.
And you'll have issues with mould and all sorts of other problems.
Yes.
That you could very happily do without.
Yes.
That you have a claim against the owner for escaping water.
Okay.
Now, the problem, normally I would have thought that the insurance company would take up your cudgels with the, in a sense, it's like a property damage claim for a motor car.
Yes.
They normally take up the action against the person who caused the accident.
That was what I thought myself.
But my expectation is, so there is an owners corporation list at VCAT. So you can take a dispute between owners corporation, between members of an owners corporation there, and you can also take proceedings under the Water Act there. So it's technically, I haven't looked to see how it works with the Owners Corporation Act, but in the normal course it's an action under the Water Act against your neighbour for the unreasonable escaping of water.
And would I also be able to make a claim for lost income from rent?
Probably not under the Owners Corporation legislation, but under the Water Act, yes. All right?
Good luck, Rosemary. Jamie in Melton, what's your issue?
Good morning, guys. Thanks for taking my call. My wife and I have been fined for not voting in the local election.
Yes.
Yes.
Does
Melton do a postal vote, or do you have to go to a voting place?
It was a postal vote.
Yeah.
And we didn't receive any ballots in the paper, in the mail at all. My wife and I, it's very unusual for one of us not to notice, hey, we've got this voting paperwork here, we better do this. We didn't realise, and now the fine's gone up to $207 each. I just wonder whether they're
Is
saying
that a notice from the Magistrates Court or from the Council?
It is now from the Magistrates Court. It's gone from $70 up to $207.
And is that an infringement court? I mean, have you told... early in the process, you get the ability to go to court to say, no, I didn't get the notice.
Right, okay. We didn't take that opportunity.
Then you're stuck.
Right.
Because you would now need to go back to court to explain why it is that you didn't.
Okay.
All right, so I can see you losing a day off work to argue about the $207 each, and you both need to go.
Right, that's right.
All right,
yeah,
so
okay.
because they're separate summonses.
I guess, David, could I just ask, is it allegedly that we received the paperwork in the mail? Can that be? Is that a proven by law fact that yes, you did receive it, and we can say that you did receive it when
you are deemed to have you're deemed to have received it. If your argument is that we didn't receive it, and if you look at my voting habit, my voting practices over the years, you'll see that I regularly vote. I just didn't receive the copy of the paperwork.
And also, Jamie, you might know it's been a massive issue. Thousands of people have faced a similar problem.
Yeah,
and I don't know that we're any clearer.
Yeah, thanks, guys. Okay.
So, have you? The other people I'd talk to would be the Victorian Electoral Commission, and I'd be actually trying to find out how many people in your local government area in Melton didn't vote, and whether that was substantially different to the last time they had one. In which case, you may then have.
I'm not sure they're willing to answer that question.
Well, there'll be statistics as to voter rollout.
Well, they weren't willing when this initially erupted. They weren't willing to talk about what had happened in the past in a specific area and what had happened this time around. But that was after the that batch of council elections led to the first round of fines.
I think it comes down to all the time that we all have to sit down and work our way through this. If everybody was to sit down and work their way through it, then we would have somewhere. But as an individual, it's quite time-consuming, isn't it?
The other issue is that the information you want in relation to the voting at council will be with council. You could ask council, and if council won't tell you, ask the ombudsman to get them to tell you. So the question is, how effective is a postal vote in and what you ought to do in circumstances where people like you don't get the paperwork. But you're at the point, Jamie, where it's going to cost you and your wife a day's income to argue about whether or not you did receive it.
Yeah.
All right.
I think that's what they're relying on, Jamie. But look, thank you. Pat's in Bendigo with a query about your surname. What is it, Pat?
Good morning, Russ and David. Probably learnt this at uni, David. Might be quite easy, but I married in 1979, changed my name. My husband sadly passed away in March. I don't intend to change my name legally, but I would like to be able to use my maiden name on something. I'm contemplating recipes on a blog that might end up in a cookbook type of situation. Can I legally use my maiden name?
Absolutely. Your birth surname.
In what sort of circumstances can I not use that name?
You can't use that in circumstances where you're intending to do it for fraudulent purposes.
Oh, okay.
So you could. There are lots and lots of people who take their kids to school and really like to have the same surname as the children at school. You know, I'm Mrs. Smith, I'm Johnny's mother. You know, as opposed to I'm Ms. Brown and I'm Johnny Smith's mother. It gets harder, but on a professional level, they retain the surname that they've had for all of their working life.
Oh.
So there's no difficulty.
It's about honesty, isn't it? Because I think you can do things with the tax office as well. It's totally legitimate to have several different surnames on your paperwork, as long as you're very clear with the tax office that when I earn all of this money, this is who I am.
Yes.
So there's a range of ways that you can use different surnames. It's not necessarily illegal to use a different name.
The real problem, Pat, is in a sense the formal documentation issue.
Yes.
I mean, you...
I would stick to my legal name, I think, in the name I've been using for the last...
Yes, but can I say, in the really interesting way, Pat, your legal name is the other one.
Oh,
right?
okay.
Because you've simply adopted by usage the other one.
Oh, okay.
The later one.
Thank you.
So where you're going to strike a difficulty is where you want to put things in a particular name.
Yes.
So the bank may be reluctant for you to have an account in the name of both Smith and Brown.
Yes.
And if you've got the driver's licence in one name and the passport in another...
I'm not going to get anywhere.
Well, no, it's just all of a sudden you're going to have to spend an awful lot of time persuading people that you are who you are.
Both people.
Yes.
But for the
or the one person with both names. Beg your pardon?
Yeah. For the purposes of the internet.
Oh, yes, you will. There's any number of people using names that they weren't born with on the internet.
Pat, good luck. There's quite a few people in public life, heaven forbid, not using actually their real name. Even some people on the radio, not this radio station, but that's I think they've been quite sensible, maintaining some of the privacy in their life. Steve is in Collingwood. Go for it, Steve.
Hi, guys. I travelled to the US recently. It's my first trip and I have no criminal record. On entering the US, as I'm sure you know, you have to give a fingerprint imprint.
Yes.
And when I did that,
I was thumbprint imprint. Yep.
When I did that, I was directed to go to the immigration counter.
Yes.
Where the immigration official told me that my fingerprint was coming up as someone else other than who I am on my passport. I was directed. He took me to a room that I'm calling immigration detention, but it was a secure room. He handed my passport over to a police officer and left me there.
My view is if you can't get out, you've been detained.
Yep.
So the door's locked on the outside. Yes, you've been detained.
Yep. So I've been detained. The police officer took my passport away, came back about 15 minutes later and said it's okay and gave me my passport back. Tried to engage him in conversation about it. He wasn't interested. went away. When I got home, I opened up my passport, and across the visa stamp, it was across the stamp for entry into the USA, he'd written a court case, Korea versus Thornburg. I looked it up. Korea was a Colombian drug mule trying to re-enter the United States in court with cocaine and was expelled.
Yes.
Then appealed that, saying that that should have been a deportation rather than an expulsion, which would have required court cases, etc.
Yes.
My question is, I've got no idea why that notation's been made.
Well,
on my
Steve, you're going to have to
passport or what
listen next week.
consequences
So I will
Okay.
have a look at Korea and Thornburg.
Yep.
And if anyone else out there wants to look at it, Korea is Correa. Otherwise, you could be spending hours looking.
Yeah. All right. Thank you. I'll listen next week.
Okay. Thanks, Steve.
Thanks, Steve. And you'll have a much better legal mind in Jon Faine opposite David Whiting. So we'll be able to sort through some of Steve's issues. And Jon Faine might even know which buttons to press and when. Sarah's in Berwick. What's your problem, Sarah?
Hi, I'm just ringing. Thank you for taking my call. I'm just ringing. My partner had a incident at work where he was injured. We did all the paperwork. He went back to work, and a day later he was sacked.
You normally get you can be sacked with cause and you can be sacked without cause. Why was he terminated?
Well, only 3 weeks prior to that, he was given a pay rise, and they just said to him that they couldn't get on with him anymore.
Then I would be suggesting that you have a wrongful dismissal action, because the only change between the pay rise and the termination was a work cover claim.
Right. Okay.
So
great.
I would be talking to someone who does employment law, and I would be looking very seriously. It's against the law to fire someone because they've got a compensation claim.
Okay.
And
right.
I can't get. I really love what you're doing, so I'm giving you some more money. You've now made a claim, so I'm sacking you. The evidentiary burden now goes to them. What is it that means that within 21 days I go from loving you to hating you?
Yeah, right. Okay. They also said to him, they wrote out the resignation and said, listen, if you sign this, we'll give you your entitlements, 2 weeks extra pay, sign it, plus a glowing reference. And my partner just went, no, sack me then. And that's what they did.
Okay. Then they do exactly what I suggested.
Excellent.
And there's the statement. They offered me money to go away.
Okay.
I declined. And anyway, even if he'd resigned, his workers' compensation claim would have still been live.
Right.
Right. So
all right.
all his rights under his compensation claim remained, even if he'd resigned, although there then becomes an argument about whether he's actually lost any income if he's given up work.
Yeah, okay.
All right.
Right.
Thank you, Sarah.
Excellent. Thank you so much.
Thank you.
Good luck. Venkat is in Tarneet. Go for it.
Hello, David and Rafael.
Thank you.
David, I got a question. This is a done and dusted case, but I just came up of not receiving a mail. While I was listening to the radio a bit earlier.
Yes, the gentleman from Melton.
Yep. Yeah, similar issue, but it's little bit serious than that. What happened some 8 years back, I was booked by the cops for making a false complaint.
Yes.
And I went to the station and they asked me what have we done, and I gave the situation what has happened, and they said okay, we're going to talk to you a bit later, and I thought that's been settled there. And after some time, after 6 months or 7 months later, I received a notice from the courts a case has been heard in the court.
Venkat, did you move in that time frame?
No, I was in the same house for 3-4 years, and even after that, I lived in the same house for 3-4 years.
And was your driver's license in the same place?
Yeah.
All right. You're allowed to look at the court file. 8 years ago, Venkat, no one's going to be particularly interested in talking to you.
Yeah.
But you could go and look at the court file,
yeah,
and you could find out how the police say they served the summons on you.
Yeah, and I did that, and they said at the court, someone came to my house and handed a letter to someone at my house. And my wife was there all the time at that house because she just gave birth to the newborn. And we were all the time at home. So, I mean, my wife was at home.
You're saying that you didn't receive a summons to go to court. You were convicted in your absence and you're facing a fine. You're just wondering how you might be able to unwind that.
The problem, Raf, is that it's 8 years ago.
Yeah, I paid the fine. But I still have a statement offence. It's not a serious offence, but
yes,
I had a
still
statement
got one.
offence. Yeah.
No, look, 8 years back, I think your ability to argue it is gone, Venkat.
Yeah, I mean, I just wondered, what should I have done at that point of time?
You should have applied for a rehearing.
Okay.
And at which stage the issue as to whether you did or didn't receive the information from the court is something that could have been addressed.
Good luck, Venkat. It's unlikely to be any help to you. But 1300 222 774. Raphael Epstein with you. Your calls to David Whiting. More of them in a moment. Some ABC News headlines with Tim Callanan. At about 27 minutes to 11, David Whiting is continuing to take your talkback calls. Some free legal advice. Mitesh is in Pakenham. What did you want to raise, Mitesh?
Good morning, David.
Mitesh.
Thanks for calling. Thanks for taking my call. I'm building a house with one of the builders, and I was working with them as a referral partner. So the things have been very clear between me and the builder, the person who was the marketing director of the company.
Yes.
The company has suddenly changed all their systems, and there's a new investor who's come in. He's trying to dig more money from everyone, and almost similar is happening to me now. So the first thing that happened with me was they said, we will not charge you anything extra to whatever is being the cost to us.
Yes.
And suddenly this person comes and says, no, I'll charge 15% extra margin to whatever we are building, whatever my cost is.
Mitesh, the issue will be, what does your contract say?
The best thing that has happened with me is they have just signed a plain HIA contract with me. No, nothing has been written on the contract apart from the price that is being adjusted. So the basic price is there, basically. It's just the basic price.
Yes.
And,
but the basic price, the contract will refer to plans and specifications. Do you have them?
Yes.
Well, the arrangement you have with the builder is a mixture of the contract, the plans and specifications, and there'll also be in that document the priority in which they are to be read. So if there's a conflict between them.
There is no, on the HIA contract that I tried to read out, there was nothing written on it except from if they don't build the house between 330 days, I have the right to revoke it, kind of.
Yes.
Before that, I don't have the right. So, and the the is very much delayed on their side. It is very much delayed.
Mitesh, the 330 days is in fact a variable.
Right.
They can apply for extensions of time. If it's a rainy day, I get an extension. There are lots of factors that will allow the builder to get an extension. What's the value of your building contract?
$480,000.
Look, for $480,000, Mitesh, I'm flattered that you should call, but I'd actually be sitting down with a lawyer and saying, well, precisely what are my rights on the basis of the agreement I have with this building company?
Okay.
And I'm concerned that they will be able to extend the days. There will be a provision in the building contract in the event that there are what are called prime cost items for the cost of those, and then there will be a provision where there are allowances for, say, bathroom tiles, and you find that you like something far more expensive, there's a margin as well as the cost. So I would, for a $500,000 build, go down and spend some time and some money with someone who can give you advice as to exactly what your rights are under the contract and how you might be able to get out of it or how you might be able to enforce it the way you want.
Okay, all right. Thank you.
Thank you.
Thank you.
Good luck, Mitesh. And Patrick's in Dandenong. What's your issue, Patrick?
Good morning, thank you. My father died recently. He was in an aged care facility in Melbourne when he died, but he made his will in 2010 in the country, and he named me and a local solicitor as being executors for the will.
Yes.
The solicitor is now semi-retired, and I had a brief conversation with him, and he said he was not interested in doing the work, which is fine. So my first question is, do I need to get something in writing from him to say that?
when you say doing the work, is he not interested in being executor?
That's right. That's what he said.
And he's not interested in doing the legal work?
No.
So what I would be doing, Patrick, is that if he will give you the will,
Yes.
then you are able to make an application for probate of the will,
Yes.
with leave reserved to the country solicitor to come in and prove the will at any time.
Okay.
He doesn't need to formally renounce.
Right.
If you want to guarantee he doesn't hang around, then get him to renounce.
Right.
But otherwise, simply make an application on your own saying, I'm Patrick, I'm making an application as one of the executors named in the will with leave reserved to X, the other executor named therein, to come in and prove the will at any time.
Okay. The will also says that he appoints the firm that he was working for at the time as being the solicitors for his estate.
What's the date of the will?
It's in 2010.
Okay. In 2009, the rules changed in relation to disclosure that needed to be provided to a client when you make a will, right? And so if I was that country solicitor in 2010, I would have been required to write to your father before the will was signed that says there could be someone else who's prepared to do it cheaper or for nothing. Right. You're able to negotiate with me as to what the fees might be. And I'm also required to tell you that the will appoints my firm to be the solicitors for the estate. And, that doesn't need to be there if you don't want it.
Okay.
So, and the rules changed about the second half of 2009.
This was April 2010.
Yeah. So your question really is was that advice given in 2009? And if it was, then you're stuck with the solicitor's firm unless they too don't want to do the work.
Right.
But if they haven't given the letter, then I would be coming along and saying, well, I don't think you should do the work because you didn't comply with your professional standards requirements at the time.
Okay. Well, for convenience, of course, we would rather deal with a local solicitor down here. In a practical sense, are they likely to say that they don't care?
Patrick, the answer also needs to be that it needs to be exactly the same firm. So if Mr. Smith was practicing with Mr. Smith and he retired and he sold his practice to Mr. Brown, so the firm is now called Brown and Smith, then it's not the same firm. Okay. All right?
Okay, Patrick.
Now, look, my policy, when I started in practice, I was desperate for work, and I always appointed my firm as the solicitor acting for the estate with the client's approval. I actually found that took, people live too long. So it never worked for me. So I've never enforced it. So have that discussion. So have a talk to the lawyer. Find out whether it's exactly the same firm. Does the right to be the solicitor for the estate extend to the successor firm? And the next question is did they send the letter in 2009? And can I have a copy, please?
Good luck, Patrick. And we'll end with Rajesh in Trigonina. What is it, Rajesh? What happened?
Hi. So what happened was I was driving out of a lane last weekend, and I had my son in the back seat, and he was nicely restrained on his booster seat. Now, a couple of 100 meters after I turned onto the main road, I had a highway patrol vehicle behind me asking me to stop, which I did. The officer came over and he said he had actually had to brake when I entered the main road and that I had failed to give way.
Yes.
Now, I accepted that, and, I accepted that it could be a judgment of error on my part. He asked for my driver's license, which I immediately complied and gave the driver's license. Now, about 5 minutes into our conversation with the first officer, his colleague got out of the car and then came and put his light on my son at the back seat, who was in his booster seat even then. But then at that point, during this 5 minutes, my son had actually opened his belt. I think there was food at the back, the food takeaway food that we had just purchased. That bag had toppled, so he actually opened his belt to keep the food straight. And he's not.
So you're saying he undid his seatbelt after you'd stopped, after the police asked you to stop?
That's right. About 5 minutes into the conversation. Right. Now, he has fined me for both for failing to give way, and also for having driving with an unrestrained child in the car. Now, technically, I wasn't driving when he actually saw that, and my argument is...
Rajesh, that's your defence. You weren't driving, but I'll have a look at the road rules because I want to make sure that the wording's right. And my next question to you is: was the car in gear?
No, it wasn't. It was stopped. In fact, the engine was off as well.
Okay, well then that's your defence.
Yeah.
But I will go and check and see whether the wording in the road rules make a difference. But if your engine is off, then you're now a stationary vehicle, you're not driving, and there needs to be some form of evidence that that seatbelt wasn't on in the time of driving.
Yes, that's right. And it took a good 5 or 7 minutes.
Yes.
And the other officer to come to even notice it. So.
Okay. Yep. Well, look, Rajesh, we'll take that as homework for David Whiting. Tune in next week when Jon Faine is back and David will be back as well. David, thanks so much.
Thank you, Raf. See you next time you're doing this.
Indeed. David Whiting, your free talkback legal advice. He joins the morning's program every Tuesday morning. You're welcome to ring and consult his broad knowledge of the law. Jon Faine will be back chatting with him next week.